Who is this Mickey Truth girl? Who qualifies her to put a work on these people?
What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So let's get it.
Comes after allegations regarding Colleton County Clerk of Court Becky Hill's conduct during the murder trial last year. It's claimed she cautioned the jury ahead of Murdaugh taking the stand in his own defense.
This is probably going to go down as the most storied trial we have ever had in the history of our state.
Attorney Eric Bland has been involved in the Murdaugh case since 2021, representing the victims of Murdaugh's financial crimes and, most recently, 4 of the jurors who found Murdaugh guilty of murdering his wife and son back in March.
They just basically said he was incredibly guilty, but at the same time, we want to make sure that the only person in that courtroom that can give direction and orders to the jury is the judge. And essentially, the clerk of court is there as a liaison between the judge and the jury.
Murdaugh's attorneys say Colleton County Clerk of Court Becky Hill tampered with the jury, making prejudicial comments against their client. The first step in determining if that's true is Tuesday's status conference.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I have talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press, but not the general public. I don't think that is in keeping with the public nature of trials in this state and public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being self-harmed to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protective as you think it needs to be.
We trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to be served.
Well, that's great, and of course you don't represent all of them.
No, our 4.
You're 4, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers? You want me to wait?
No, sir. You can. I don't need that at this moment.
Okay. Thank you. Thank you, Judge.
Yes, sir. Mr. McCullough.
Sorry. Would you like me here or there?
Go to the podium if you would, please.
Your Honor, I believe that some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course.
How many jurors do you represent?
I'm sorry, Your Honor. I represent number 785 and 630. One is was a deliberating juror, I suppose we could call her, and the other was the removed juror.
Right. Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I rule that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootlian is going to submit additional information As regards your client, I'd ask you to submit that information to you as well. And then I'll see if there's any review of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not an alternate. She was actual seated juror.
That's right, the sitting juror.
Who was removed at the end of the trial.
Oh.
Prior to deliberation. Oops.
I need Ms. McCullough to speak up, please.
You need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and is part of your record. And my letter of November 10th responding to that filing is also part of your record. The state said that jury duty is this cornerstone civic duty, needless exposure to the jurors to litigative stress and impeachment by zealous attorneys in a case, especially of this public exposure, can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, attorneys.
Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. A negative commentary doesn't, or raise the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I like Mr. Richter and Mr. Bland, appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and there will be a code that we can direct it to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and the media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery, a full gallery of press, by allowing its recording through, I understand, court TV will be the full camera. That is to say that I have actually, in my history, participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying, and I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
Thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent rulings.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors to be the first witnesses to be called in these proceedings. And the jurors will testify, and then they will be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they need would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off of work?
yes, I do.
Okay, thank you.
All right. And Mr. Lewis.
I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need him, and happy to accept service to alleviate one issue for this court. Unless you need anything from me, Your Honor.
All right. Thank you for that. And before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you. That wouldn't be fair at all. But I'm going to ask them if there's anything else I need to inquire of before I let you go. As I understand it, if the subpoena, and we would have a formal subpoena of Ms. Hill, would be placed in your hands as her attorney. And you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
We'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all day.
She should be here as court witness.
All right. Thank you. Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
I'll go over my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. All right, so I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proffer. All right, first of all, for the defendant.
Police Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, At that point, we'd say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope you found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpootman. I've told you that I can't imagine a situation in which I would go that far. So a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
But there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, the questions of why she would have done this extraordinary act, and we can argue this at another time, but in terms of the reason I mention it is for us to proffer those people now, not knowing what she may admit, that question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any of the jurors and what she said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes, sure.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to juror issues. And while he is no longer a lawyer, he was a lawyer at one point and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Burke has not been able to keep for himself while I'm not there confidential materials.
That's correct.
That is something common to many folks who are under incarceration are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there, or your representatives are not there, and study upon it or so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something that's pretty specific, but I can tell you this. I would certainly not order that these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is, not my making or yours.
Your Honor, I would only note for the record this: much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client and effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, you know, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or is the reason why we're standing here and litigating these issues before Your Honor. Ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters the court would rule. The only way, though, that I can see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make it very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. This an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopkins, and I particularly thank you as a member of the General Assembly for not imposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Payne's order. But I realize that I'm doing that with your extreme cooperation in light of the other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
All right.
Parties, what's going on? I asked Ms. Harris before these matters commenced. To please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce the transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order it, sharing the expense of this production, this early production of the rough copy of this matter. She will be in touch with you. You may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
All right, y'all. All right, y'all. So for those who didn't know what we were watching just now, that is Alex Murdaugh. Okay, he is the lawyer from the Low Country in South Carolina that murdered his wife, murdered his son, and took money from his law firm. Okay, he is currently serving, I want to say double life, if I'm not mistaken. A double life sentence. Matter of fact, let me verify that. I do believe he got life. But while I'm looking that up, so what's going on now is that he is claiming, or somehow somebody is claiming, that the jury was tampered with. You heard him, the judge and some of the lawyers bring up a name of Miss Hill, which is the person they're saying tampered with the witness, because by him being convicted, it was gonna, like they said, make for a better book and get more sales. So yeah, that's why we're here. And it could be, and I'm gonna be honest with y'all, right? If they get their way, he could technically have a situation, okay? For real. But yeah, so currently he is serving 2 life sentences. Yeah, for murder, 2 life sentences for murder. Now, he does have other things going on. Like I said, he is accused of defrauding his law firm. I think they may be sticking to the civil on that, but I'm not 100% sure on that. Okay. A lot of people, when the trial was actually going on, the murder trial, a lot of people said, Mickey, are you going to follow it? But y'all know how I am. If I get to something too late, I'll be like, I can't catch up. And I'm going to be honest, I'm still catching up with the actual trial, but I am familiar with the case itself because it's a big thing here in South Carolina. So for those who don't know, this is a South Carolina case. I mean, they got documentaries of this on Hulu, Netflix, everywhere. So I'm going to be catching up. But right now, they're going through the process of attempting to poke holes in the situation and say, hey, we must overturn his conviction for the murder because of jury tampering. And I'm going to be honest, our Attorney General, what is his name? He'd have been our Attorney General for so long. What is, I can't think of it. But anyway, he said, hey, I don't care what they say. He's not getting out. So this is definitely something major. So the next hearing is on the 29th of the month. They had some discussion during the hearing today about Court TV streaming it live. So I'm gonna have to look into that, because if that is the case, I may have to pull up. Now let me tell y'all something. Like I told y'all, hey, all I see is descendants of slave owners when I watch that thing. Okay. When I say that's down there in the Low Country, I mean do your research on South Carolina, okay? Some people's ancestors, okay, arrived to what we now call the United States from the Low Country of South Carolina. Y'all can fill in the blanks what I mean by that. So I personally, okay, would rather not go attend the trial in person, but I will, nevertheless, which as y'all can see, what they said on the blind side, I'll be like a flying milk in that proceeding. So we'll take a look and see what happens. Let me see. Has he gotten in trouble? Abuse of privileges, unauthorized use of an inmate's pen. And see, this is another thing why they have that order where he can't have the material with him, because he's already using other inmates' pen, okay, to make calls and stuff. And again, before all this took place, he was a high-powered attorney, okay, with high-powered friends, and they're fearful that possibly information could be provided out and things could happen to people, right? That's the whole point of them even doing the no contact order. So, like I said, this is just the status hearing. The next hearing is scheduled for January 29th. Definitely, y'all, I'm gonna do my best to try to do a quick recap. I wish Gates was in here, because Gates followed the trial. But it is a Netflix or a Hulu, I can't remember which one, that has a series on it. I'm actually going to watch it to catch up on it. And then we're going to follow it from this point forward. We're going to follow it from the jury tampering stage forward. So that's pretty much it, y'all.
So what is a status conference? The American Bar Association explains it as something that comes after all initial pleadings have been filed to, quote, help the judge manage the case and establish a time frame for pretrial activities. Justice Jean Toll, who's presiding in the case, will meet with the defense and the prosecution ahead of the main hearings that begin January 29th. It's during those hearings that we'll hear testimony on why Murdaugh does or does not deserve a new trial. Tuesday, she'll set the ground rules for those hearings.
She's going to lay out the format. She'll say what time things begin, who does what she is willing to entertain.
And also, if the defense is able to issue subpoenas to go through the jurors' phones. I spoke to former U.S. Attorney Pete Strom, who is not related to this case, to get his legal opinion on what's to come.
Courts don't like to reverse juries, okay? I mean, you know, a lot of work and time has gone into this case. The other side, the defendant's got a right to a fair trial. I hadn't seen anything yet that convinces me that there's going to be a new trial. Now, I hadn't seen it all. I've read what's been reported. I get the legal arguments, but one word, one way or the other, during this evidentiary hearing would change my mind.
Like, comment, share, subscribe, tell a friend to pull up on your girl Mickey Truth. And as always, donations are welcome to support the channel. Hit the Cash App, Mickey Truth 2022. Holla!
Shout out Mickey. Mickey, you gonna be big.
I'm trying to conquer the world. Coming